President Trump suffered a rare loss at the Supreme Court after justices ruled the administration cannot deploy the National Guard to the Chicago area. After more than 2 months of consideration, the High Court, in a 6-3 decision, rejected the government's emergency request and refused to pause a lower court's ruling that temporarily blocked hundreds of National Guard troops from being federalized and allowed to patrol across Illinois. And as we head into 2026, Trump is facing major legal decisions that could shape his presidency over the next 3 years. From tariffs to the ability to fire members of independent government agencies, it's shaping up to be a blockbuster 2026 at the Supreme Court. Here with more is the Hill's courts and legal reporter Zach Schoenfeld. Hey, Zach, so regarding this ruling on the National Guard, this is a setback for the Trump administration, especially coming from a Supreme Court that often ruled in favor of the administration in 2025. Break down the court's ruling and what it means going forward for the deployment of National Guard troops across the U.S.
Hey, Drew, this is a big loss for the Trump administration indeed at the Supreme Court. As you mentioned, they've really been racking up wins ever since the president's inauguration, and this is arguably their biggest loss on the Supreme Court's emergency docket, going all the way actually back to the spring and just the early weeks of the Trump administration. So a major loss here as the justices in this emergency decision saying that the president cannot federalize and deploy hundreds of National Guard troops in the Chicago area. Drew, this case really comes down to the federal statute that President Trump cites, which gives him authority in some circumstances to deploy Guard troops on American soil. Specifically, the statute requires preconditions be met, one of three. And so this case really focused on one of the ones that Trump had cited that says that he must show that regular forces are unable to execute the laws. That had been his justification, but the Supreme Court in this ruling rejecting that, at least as of this stage. I'll just read you a little bit from the court's opinion here. Actually, despite this being an emergency decision, we actually still did get a little bit of explanation here. The court writing that, quote, thus, at least in this posture, the government has not carried its burden to show that, and they give the statute number, permits the president to federalize the Guard in the exercise of inherent authority to protect federal personnel and property in Illinois. So the bottom line here, Drew, is that the president cannot use this statute to send Guard troops out on the streets in Chicago to protect some of those ICE agents at ICE facilities and elsewhere.
So, Zach, this was a 6-3 decision, meaning 3 conservative justices ruled against Trump. What was their reasoning?
Yeah, so let me start by getting a little bit more into the weeds of the majority here. And that is, I mentioned before, it has to do with this provision that says the president has to show that he is unable to execute the laws with regular forces. And the Trump administration had made the argument that regular forces includes ICE agents, DHS agents, and some of these other, civil enforcement that has been on the ground. And so they made the argument that as you look to places like this Broadview ICE facility in the suburbs of Chicago that has gotten a lot of attention, where we've seen protests that have at times turned violent, saying that those ICE agents have been unable to execute the law. But the basis of the Supreme Court's decision is saying that that statute, when it says regular forces, it's actually a reference to the U.S. military, and so that these ICE agents don't count, and that the president would have to show that the military was unable to execute the law. Now, there's 3 conservative justices in dissent. It's actually 2 separate dissents here. I'll focus on the lead dissent from Justices Samuel Alito and Clarence Thomas. They at times are taking issue with some of the majority's reasoning here. At a point, they say that the majority is actually reading more into the statute that is actually there in the text, and so that they are saying here that the Supreme Court is getting it wrong on those grounds.
Justices Alito and Clarence Thomas wrote in a dissenting opinion that the High Court unnecessarily and unwisely departed from standard practice. Can you explain what they're arguing there?
Yes, I can. And not only are they saying that the Supreme Court majority, their colleagues, have gotten this issue wrong, they say they shouldn't have actually even reached this issue, because this idea that we've been talking about, this debate over what does regular forces mean, this has been an issue that the Supreme Court had actually had to direct the parties to submit an additional round of written arguments on before this decision came in. And so the argument that you're seeing in this dissent from Justices Thomas and Alito is saying that, hey, the parties never originally gave this argument, and they're saying that it is not our role as the court to essentially pick out this argument of our own to rule against the Trump administration, saying that the court here, shouldn't be playing that role of advocate, leave that to the lawyers. And so they say that the Supreme Court was really wrong to even get into that in the first place, saying that it really wasn't properly before them.
Hey, Zach, so you wrote today in your latest version of the GAVEL newsletter that President Trump's naming spree is drawing legal scrutiny. He has added his name to the U.S. Institute of Peace, the Kennedy Center, and even announced a Trump class of battleships on Monday. Does the president have legal authority here, or will these moves end up getting tied up in long legal battles?
Drew, I think when you look to an issue like this, you have to kind of take each one in its own bucket because each of these renaming decisions involve different legal authorities and different questions. For example, take the Kennedy Center, because that's the one where we're actually seeing a lot of activity in court this week. A Democratic member of Congress has now filed a lawsuit in federal court seeking to stop that. This is actually a member of Congress who is a member of that Kennedy Center board that voted to add the president's name to the building. And the argument in that lawsuit is saying that it was an act of Congress that actually set up the Kennedy Center and gave it its name, the John F. Kennedy Center for the Performing Arts. So saying that it is only Congress that actually can make a change here and add President Trump's name to the building. So they are now asking a federal judge to block that. But some of these name changes, Drew, that's not only the Kennedy Center, you've seen this play out in different contexts as well. Just to give you one more example, we actually are now seeing a lawsuit over national park passes, because now in 2026, there is supposed to be on the America the Beautiful park passes, it is going to be an image of President Trump. And that lawsuit claims that, there's a provision of federal law that actually says that image on the national park passes has to be decided as the result of a photography contest. And saying that didn't happen here by just slapping a photo of the president's name here. So these issues are starting to come up in court, but really each one of them, Drew, is a bit of its own unique circumstances.
You also wrote in your newsletter about the Department of Justice's Second Amendment section. Talk with us about what exactly that is.
This is part of the remake that we have seen of the Justice Department's Civil Rights Division, where we've really seen the Trump administration, after coming into office, reshaping that division and focusing on the priorities that we know that the president has and through his executive orders and his administration. And so this announcement that the DOJ is going to form what it's calling a Second Amendment section, really I think it goes to show just how much focus that the Justice Department is putting on gun rights. Just this week, we saw the lawyers in the Second Amendment section sue in D.C., suing over D.C.'s AR-15 ban that prevents firearm owners from registering AR-15s and certain other assault weapons as well. And so you're now really seeing the Justice Department going on offense and suing over those laws. Of course, D.C. isn't the only jurisdiction that has one of these AR-15 bans. There's a number of other blue states that do as well. But really now, this is just the latest sign of the Justice Department going on offense here on the Second Amendment.
I want to go back to the Supreme Court. President Trump has some major court cases that will be decided in 2026, probably the biggest being his tariff policy. The court's ruling will shape the president's economic agenda and could send shockwaves across global markets depending on how the court rules. The fact that so much is at stake, could that weigh on the court's decision? And when can we actually expect a ruling?
I think the justices will tell you that does not weigh on their decision, that they believe that they are looking at the law and then making a decision accordingly. But no doubt, Drew, that the decisions that we are going to see from the Supreme Court in the coming months are going to have massive impacts on whether President Trump can carry out signature policy items on his agenda. This is now coming into, as we get into 2026, we start to think about that Supreme Court decision season. A lot of the decisions tend to come out in May or June, but they do start doing those opinion releases historically. That does, you'd expect that to start up soon. So we could see some of these opinion announcements coming soon. And when you think of a case like the president's tariffs, that is a case that the Supreme Court is actually hearing on an expedited timetable. So the big question now is, does the Supreme Court wait until that typical May and June decision timeframe, Or do we get that decision sooner? Does it come more like the late winter or early spring? So that is certainly a possibility with the president's signature economic agenda on the line. His attorneys have minced no words in warning the Supreme Court about the consequences. They have said ruling against the president essentially would cause financial ruin for the country. You've even seen the president continue to make a series of Truth Social posts warning the Supreme Court about ruling against him in this case on tariff. So that's certainly going to be a big one. But as you mentioned, Drew, there's some other big cases as well with independent agencies and the like.
The Supreme Court has allowed the president to remove Rebecca Slaughter from her position at the Federal Trade Commission. She was the last Democratic member of the commission. In that case, the court will also decide whether to overturn a 90-year-old precedent that allowed Congress to create independent agencies insulated from political interference. If the court rules in favor of the president, what precedent will that set?
It really could greenlight the president's efforts to fire independent agency leaders all across the government without cause. At issue before the Supreme Court, as you mentioned, Drew, is this precedent. It's called Humphrey's Executor. It goes back to 1935. That has paved the way for Congress, for some of these multi-member expert agency boards, to set them up with protections that prevents these leaders from being fired from these boards unless the president actually has valid cause. And what we've seen the president do in his second term for many of these leaders, including Rebecca Slaughter at the FTC, when he fires them, he doesn't purport to have cause or to be following that statute. But instead, the Trump administration has engaged in a project saying that all of these removal protections are unconstitutional, arguing that they infringe on his ability to oversee the executive branch. This is part of an expansive view of executive power. You'll hear it sometimes called the unitary executive theory, the idea that the president has near or total control over the executive branch. And so with the Supreme Court conservative justices, we know that several of them, they have been really casting doubts about this 90-year-old precedent that has allowed for these removal protections. And now the president's hope is that by using this FTC case, that they will strike down that precedent once and for all. And if they do, it would greenlight the president's efforts to fire these leaders at the FTCs and actually a few dozen other independent agencies. I always call them the alphabet soup of independent agencies because it's like places like the NLRB, the MSPB, and all of these other various agencies that are all across the government. So this really is one of the biggest Supreme Court cases of the term heading into 2026.
Yeah, you talk about the power of President Trump to oversee these independent agencies that's being tested here at the Supreme Court. Justices will rule on whether a president can fire Federal Reserve Board member Lisa Cook. The court has allowed Cook to remain on the board for now, but walk us through what impact the justices' ruling will have in this case.
Yeah, Drew, this is a really interesting case because as opposed to all of those other agencies that we were just talking about, where President Trump has fired those leaders, not purporting to have cause, but believing that he has inherent constitutional authority to fire them, you compare that to the Federal Reserve, which has really been the 800-pound elephant kind of in the room for all of these cases. And the president there has really tried to treat the Fed differently because when he has fired Lisa Cook, he actually purports that he does have valid cause, and he claims that he is following the statute. And that's why you're seeing President Trump really focus on these accusations of mortgage fraud against Governor Lisa Cook, because he says that amounts to valid cause, under the statute. And so, the Trump administration has told the Supreme Court, no matter what you're going to do with the FTC and that 90-year-old president, that really doesn't impact here. They say that this is just a straightforward case of, did the president have valid cause here against Lisa Cook, and did he follow the statute? And they say you don't have to go any further than that. But of course, we know that the Supreme Court is going to be considering this case as they also consider those bigger questions about independent agencies. So it really is an interesting case, and this Fed case is one that's going to be going to oral arguments just here in a few weeks in January.
All right, one more before I let you go, Zach. What other court cases are on your radar heading into 2026?
Drew, we've talked a lot about the cases at the Supreme Court that are impacting the Trump administration directly, where it is, on the line is some policy agenda item. But it really is a blockbuster term with the Supreme Court because they have several other big cases on their docket as we head into 2026. This past fall, we saw big arguments in a case surrounding the Voting Rights Act, the future of race-based redistricting under the Voting Rights Act that could have big impacts for the future of majority-minority districts, could impact, the control of the House in the future. So that'll be a big case to watch. And another one that's actually coming up for oral arguments here very soon at the Supreme Court. It'll be held very close to the Fed arguments that we were just talking about, are the arguments over the future of states that have passed transgender athlete bans. The next big case here in the fight over LGBTQ rights. We, of course, saw last term the Supreme Court get involved in the fight over gender-affirming care. This is now really the next phase with these athlete bans, and, of course, a big case that's going to impact laws passed in red states all across the country. So a big term at the Supreme Court this year, Drew.
All right, Zach, always great to have your insight, and you too at home can have his insight right in your inbox. If you subscribe to The Gavel, head over to thehill.com, click on newsletters, and have The Gavel delivered right to your inbox. Zach Schoenfeld, thanks so much for your insight, as always.
Thank you.